You expect it from the government. You expect it from the media. You even expect it from the general public at this point. But once the courts stop listening to reason or fact and instead start believing in propaganda, then we are truly lost. So what does Justice Kane think about assault-style firearms? Let's have a look. Welcome back to the channel. So today we're going to be continuing our CCFR versus Canada series. In our previous video in the series, I conducted an independent analysis of what constitutes an assault-style firearm and established what it is, and perhaps more importantly, what it isn't. Now, as definitive as that might have all been, the actual point of this series is the CCFR versus Canada court case. So the better question to be asking is, did Justice Kane have enough information presented to her in the case to have come to the same conclusion on her own? Her coming to an unreasonable interpretation wouldn't necessarily be indicative of any shortcoming on her part if the participants in the judicial review failed to provide her with enough strong evidence and reasoning to help her form the proper conclusion. In part 2 of the series, we took a look at some of the glaring inadequacies and biases that Justice Kane displayed towards the applicants' arguments and, therefore, also towards us firearms owners as a whole. Chief among these issues was the fact that Justice Kane wholly avoided the issue of rigorously defining what an assault-style firearm actually is, despite it being, essentially, the entire basis for the order in council as described in the Rias. And that, by extension, should have made it the focal point of the entire case. Justice Kane refused to discuss the definition of an assault-style firearm because in her view it was unnecessary since it was a term that didn't actually show up at all in the regulations. It only showed up ever in the Rias. However, in conducting a judicial review under the Vavilov standard of reasonableness, it was expressly her job to do so. And Vavilov says, in conducting a reasonableness review, a court must consider the outcome of the administrative decision in light of its underlying rationale, to ensure that the decision as a whole is transparent, intelligible, and justified. Judicial review is concerned with both the outcome of the decision and the reasoning process that led to that outcome. To accept otherwise would undermine, rather than demonstrate respect towards, the institutional role of the administrative decision-maker. So according to Vavilov, which is the legal standard of reasonableness being used in this case, it's not acceptable to simply analyze the regulations at face value, but we must also be dissecting the underlying rationale behind them. The core of this underlying rationale is the concept of what constitutes an assault-style firearm, and that these so-called assault-style firearms are more dangerous than other firearms. And this is a term that was used literally 20 times within the Rias, which is why it's so bizarre that Justice Kane was completely okay with leaving the term undefined. Now, the OIC does actually mention these 4 criteria as the basis for the definition which Justice Kane often refers to, but she also didn't scrutinize this information either. If she had, like I will do in part 4 of this series, she wouldn't have been able to rule in favor of the government, which could be very well why she avoided doing her duty in the first place. And this is because the criteria doesn't actually align with the firearms on the list, which is something that our applicants did specifically criticize, but once again, we saw Justice Kane opt to avoid the issue. It's worth noting that from even within the case itself, and from the government's so-called experts like Professor Brown or Mr. Smith, even from these people there was pretty severe contradiction in their testimony for what an assault-style firearm is or isn't, or what a variant is or isn't. And some of this information even contradicted the opinion given by the governor and council as stated in the Rias. Now, given that the government can't even get its own story straight, this leaves us with obvious questions. If we do not define this term, how can we know that the regulations actually align with the stated intent? Or worse, how can we ensure that the government isn't trying to attain some colorable or ulterior motive other than public safety? But more simplistically, if it is left undefined, how can we actually guarantee that only assault-style firearms are actually on this list? Well, the RIA says that assault-style firearms are a problem because the newly prescribed firearms are primarily designed for military or paramilitary purposes with the capability of injuring, immobilizing, or killing humans in large numbers within a short period of time based on the basic characteristics they possess, such as a tactical or military design, and the capability of holding a quickly reloadable, large-capacity magazine. While some of these newly prohibited firearms were previously used by individuals for hunting or sporting purposes, it is the view of the government that these firearms are unreasonable and disproportionate for such purposes. So contrary to what Justice Kane decided to focus on in her ruling, the threshold of what makes an assault-style firearm a problem is not its inherent deadliness, but rather its disproportionate deadliness. Now, in fairness to Kane, the government does most often refer to it as inherent deadliness in their OIC, but Justice Kane is the one conducting the judicial review. It is entirely her job to scrutinize. And inherent deadliness would be an insufficient standard even under her perverted interpretation of the powers given in section 117.15 of the Criminal Code, since all firearms are inherently deadly. And this is something that the applicants pointed out regularly during her ruling, but Justice Kane once again glossed over it and chose to not address their very valid criticism. And again, likely because if she did address it, then it would immediately dismantle the government's case. An inherently deadly firearm couldn't be unreasonable for hunting or sporting purposes, because even the firearms which are reasonable for hunting and sporting purposes would also be inherently deadly. And as such, only disproportionate deadliness could be the sensible criteria. However, she only mentions disproportionateness once in the entire ruling, and only during a quoting of the Reis. And even the Reis itself mentions it only once. Whereas Justice Kane's ruling goes on to mention inherent deadliness 6 times and inherent danger a whopping 20 times. She often uses inherently dangerous in her own words as the standard. And she never referred to any threat or harm from assault-style firearms as disproportionate even once, indicating that both she and the government clearly subverted even their own false idea of the intended meaning of section 117.15 subsection 2 of the Criminal Code. So, how do we actually go about defining what an assault-style firearm actually is? Well, in a reasonableness review, we're supposed to be taking a look at the relevant factual and legal constraints on the decision. So we'll be looking at the relevant law, as well as the legal purposes and objectives of the OIC, and the factual justifications declared by various experts within the case to eliminate any flaws in the overall logic of my proposed definition. Now, first and foremost here, the firearms that are on the list, including the ever-infamous AR-15, don't actually violate the official assault-style definition as laid out by the Liberals in Bill C-21. So what that means is if all you did was take them off this list, AR-15s, along with all the other firearms that are on the OIC list, would not violate any other rule the Liberals have invented thus far since they've been in power. AR-15s would be completely legal. And this indicates to us that AR-15s do not actually legally possess any capability deemed beyond safe civilian use. The Liberals have had every opportunity over the past 9 years to pass new laws limiting the capabilities of firearms for legitimate civilian use, and they have made no significant changes on that front. Of every new rule they have passed, AR-15s, still to this day in 2024, comply with all of them, except for the fact that they were singled out by name and put on this list. That being said, we're not going to use this cop-out. Bill C-21 and the Evergreen definition within it came several years after the OIC, and this video series is about the 2020 OIC court case. So as such, we're going to limit the discussion to information which was available no later than May 1st of 2020, in order to avoid any kind of hindsight debate. I just wanted to point out that even the government, which invented the term and the OIC list itself, doesn't appear to believe that AR should be legally defined as an assault-style rifle, according to their own invented and legally enshrined definition. So if assault-style firearms can be more than just what the Evergreen definition says they are, then what are they? And in order to avoid any confusion on the issue, we're going to get magazines and magazine capacities out of the way. If the definition was as simple and one-dimensional as magazine capacity, then we could simply have a discussion about lawful magazine capacities. All centerfire magazines in Canada are already limited and have been limited since 1991, later enshrined in 1995 by the Firearms Act. This makes it so that all semi-automatic centerfire rifle magazines cannot legally hold any more than 5 cartridges, and all pistol magazines, centerfire and rimfire included, cannot hold more than 10 cartridges. So from a legal perspective, any discussion about some firearms having higher capacities than others is a moot point. Our laws already prohibit any firearm from exceeding these capacities, regardless of whether or not it is an assault-style firearm. This also indicates that if magazine sizes were the issue, then the reasonable response would be to legislate different magazine restrictions rather than to wholesale ban entire firearms. This shows that the law already understands that magazines are not firearms and firearms are not magazines. They are 2 entirely separate issues. Additionally, all throughout the case, the Attorney General's experts refer to assault-style firearms by the design of the firearm and not by the magazine. In fact, magazines are mostly irrelevant in the determination according to them. Government expert Mr. Murray Smith even specifically mentions this in his testimony. On page 234, it says, with respect to interchangeable parts, Mr. Smith noted that the focus is on its core parts, such as the bolt, the receiver, the bolt carrier, and the barrel. and that some parts are far less important, such as the sighting equipment and the magazines. So now that we've got the issue of magazines out of the way, and we've narrowed down the conversation to firearms only, what is an assault-style firearm? Well, funnily enough, the government expert testimony shoots itself in the foot yet again. Professor Brown says that an assault-style rifle refers to a semi-automatic center-fire rifle that can receive a detachable magazine that originated from a military design. So an assault-style rifle is not just any semi-automatic rifle, or any center-fire rifle, or any rifle with a detachable magazine. It's only those who has all of those features simultaneously, which then also originates from a military design. If we combine this with some of Mr. Smith's definition of what a variant is, we see that he has the same criteria. He says the important criterion in establishing whether a firearm is a variant or not is the lineage of the firearm. And that means whether it is derived from the original firearm or not. He also says that a variant is a firearm whose design was derived from the original firearm. So whether they are describing an assault-style firearm or a variant, they appear to have the same criteria. It's any firearm whose parent design or original design is a military design. And this also means that the term variant can be used as a workable definition for what an assault-style rifle actually is. An assault-style rifle appears to be defined by the government experts as a semi-automatic variant of an assault rifle, even though they never actually specifically state this outright. However, this interpretation of the term is also consistent with what the RIA says about them. If the sole purpose of the OIC is to ban assault-style firearms, and thereby it also bans its variants, then all variants must also be assault-style firearms, meaning the criteria for establishing what a variant is the same criteria for establishing what an assault-style rifle is. However, this is actually where we start to run into some conflicts. As I've shown many times in this series so far, the definitions proposed by government experts like Mr. Smith and Professor Brown are rather complicated, nuanced, and full of contradictions. Even where the criteria is relatively straightforward, it's still a highly technical analysis to determine something like the lineage of a firearm. It's something which requires a pretty significant amount of expertise and something to which there can be disagreement even among the experts. Now think about that complexity in contrast with the RIAS and Professor Brown's testimony. The RIAS states quite often that the reason they decided to ban assault-style firearms was due to growing concerns from the public over public safety. And in Professor Brown's testimony, he also spoke to public support of bans and cited a couple of polls suggesting that roughly 4 out of 5 Canadians support bans of assault weapons. So if it is true that the government is acting in the interest of the public, and if public interest is enough to justify their actions, then they also must be acting in a way simple enough for the public to understand. The poll from Ipsos stated that 82% of Canadians support a ban on assault-style firearms, and, okay, fine, but I guarantee you that 82% of Canadians do not even remotely have the level of expertise necessary for understanding the complexity of establishing the historical lineages of a supposed assault-style rifle. So whatever Canadians are saying that they want to ban, it can't be a firearms lineage because the public fundamentally lacks the expertise to analyze that. The Attorney General wants to rely on hyper-complicated expert testimony to justify the OIC and to get away from issues of credibility due to criticism stating that they're just banning firearms because of what the firearms look like. But by doing so, it also invalidates the original basis for the OIC, which was public support. So whatever an assault-style rifle is or isn't, it must be something simple enough for the public to understand if the basis for the enactment of these bans is public support. And not only that, but even members of the public who ought to be well informed enough, such as gun control lobbies like Police Souvient, even they aren't capable of that level of analysis. If you take a look at this Twitter post from Police Souvient, and frankly most of their social media posts as well as official documentation, they advocate for this firearm being banned. They call it an assault weapon, not just an assault-style firearm, and they demand that the government goes ahead and bans it. But this is the Crusader Arms Crypto. It was designed from the ground up in the last year with the intent of being compliant with all current firearm regulations and even the new Evergreen definition set out within Bill C-21. It was even designed intentionally with new 5-round proprietary magazines which are permanently incapable of holding more than 5 rounds, instead of the normal AR pattern magazines which had just been pinned. Magazines like these. But despite all that, it would absolutely not qualify as a variant or as an assault-style firearm because it does not have the lineage or pedigree to substantiate that claim. Yet, if you were to ask Polly, or probably any member of the public, or frankly even if you ask me, we would all probably agree. That is an assault-style firearm. Meaning that the requirement of lineage for determining variants or assault-style firearms is not actually a valid criteria to be used, as it directly contradicts the original justification of the OIC to begin with, which was public support. The issue of lineage is a criteria which was added by lawyers after the fact to give validity to an otherwise flimsy legal case. And if somehow it actually wasn't, it forgets the very important threshold that the OIC is supposedly based on. Danger, harm, public safety. Slightly changing the size or the shape of the bolt, or increasing the length of the frame by a centimeter, or repositioning the placement of the pins in order to make it not a variant or to break lineage, doesn't really make the firearm any more or any less dangerous. Lineage is decidedly a wholly irrelevant factor to public safety, which is supposedly the underlying goal of the OIC to begin with. So, what is it? What is an assault-style firearm? Well, after all this, we finally have enough information to narrow it down. If we're not talking about magazines or lineage, then the rest is pretty straightforward. Without those two criteria, our government experts give us a definition which jives exactly with what the public, the gun control lobbies, and even the gun lobbies claim. And Mr. Smith clearly indicates what it is for us after we dismiss the senseless lineage of the design criteria. And he says that the Specialized Firearms Support Service will consider several things. In particular, the appearance and position of user controls. He goes on to say a common appearance may indicate that a firearm is a variant. And he again says, the appearance of a firearm is an indication of the intention of the manufacturer to produce a firearm that was a member of the target family. It also, generally, duplicates the ergonomics of the parent firearm. So according to the evidence presented at trial, it comes down to appearance and ergonomics. That's all it is. And that is all that it is.
Anyone who says differently is selling something.
This is further backed up by more critical information that Justice Kane willfully omitted from her ruling. But thanks to the CCFR putting these documents online, I can take a look at the cross-examination the applicants did of Mr. Smith. The government's own expert, in his own words, states very firmly and in no uncertain terms that mechanical operation is not a requirement in determining whether a firearm is a variant, or therefore, whether or not it's an assault-style firearm. On cross, this question was asked to Mr. Smith. So what you're saying is that even without any mechanical interchangeability or similarity, it's possible to have a variant based on the appearance alone? And then Smith responded, well, it's more than just appearance. It's also the ergonomics and the purpose of the firearm. But to answer your question about the mechanics of the firearm, no, there is no requirement for any mechanical commonality. And in fact, there are numerous examples in the explicit list of the firearms in their regulation themselves where a firearm is identified by the Governor and Council as being a named variant of a particular firearm and it shares nothing mechanically with it. Like, come on, Justice Kane, what are you doing? Like, oh man. So that was said as part of the evidence submitted to Justice Kane by the government expert. Yeah. Shortly later, Smith was then asked, okay, so basically we still have a situation where the classification determination is, to use Mr. Charwanak's language, essentially a lottery? And he says, no, that's not true at all. The issue of the similarity in operating mechanisms is answered very clearly by simply perusing the regulations. And you can see all kinds of examples listed in the Criminal Code regulations by the Governor and Council explicitly as variants where there is limited or no mechanical similarity, and yet they're still prescribed as being variants. However, the government and the gun control types would still have everyone believe that an assault-style firearm is more dangerous than a normal firearm because of this cosmetic or ergonomic difference. But cosmetics don't make a firearm dangerous. Capabilities make a firearm dangerous. So what capabilities must an assault-style firearm have in order to make them disproportionately dangerous as compared to other firearms? Well, the same capabilities that make any firearm more dangerous than any other. Lethality, capacity, and fire rate. So now we have to ask the question, do some firearms have increased lethality, capacities, or fire rates based on their appearance or ergonomics? No, they don't, of course not. But that question would probably not be satisfactory for a court or for the gun control types in the world, so let's phrase it in a way which would suit them. Do assault-style firearms have increased lethality, capacities, or fire rates as compared to other firearms? Now, we've already established that magazines are irrelevant to the nature of an assault-style firearm, according to government expert Mr. Smith, so we're left with lethality and fire rate. First up, do assault-style firearms have increased lethality? Well, keeping in mind that we established that it's merely a cosmetic criteria, the answer is no. Of course they don't. That's completely ridiculous. Government expert Mr. Smith even says as much. On page 234, he says, cosmetic appearance does not affect the lethality of a firearm. Very clearly, very plainly, it's right there. So with lethality and capacities out of the way, we have one last hurdle: fire rate. On page 348, government expert Professor Brown claimed that the cosmetic difference of assault-style firearms isn't just cosmetic, but rather that it is the result of design following function. Well, what did he mean by that? Justice Kane never actually explains this phrase in her ruling, nor does she quantify it in the annex, which I suspect is because she didn't want to put this nonsense down in writing. But again, thanks to the diligence of the CCFR putting all these court documents online, we can take a look at Professor Brown's affidavit to see what he meant by that term. And in paragraph 31 of his affidavit, he says, critics of prohibitions of assault-style firearms frequently claim that these guns were regulated simply because they had a supposedly threatening appearance. However, American writer Tom Diaz has emphasized that the look of assault-style rifles is not cosmetic, but it is, rather, designed to ensure that the person wielding the firearm can discharge it quickly and accurately. The assault weapon's physical appearance is the result of design following function. All assault weapons, military and civilian alike, incorporate specific features that were designed to provide a specific combat function. And that function is laying down a high volume of fire over a wide killing zone, also known as hosing down an area. Civilian assault weapons keep the specific design features that make this deadly spray firing easy. So Professor Brown's principal argument for design following function is him loosely paraphrasing a book from an author who is not actually talking about assault-style firearms, but rather is talking about assault weapons, which, by the way, are entirely different things. And that author is saying that the cosmetic appearance directly enhances the ammo capacity and fire rate. But again, we've already dismissed magazine capacities because it's an unrelated issue, so Professor Brown is essentially claiming that assault-style semi-automatic rifles have increased fire rates over other semi-automatic firearms. But obviously they don't. They're all semi-automatic. Their fire rate is the same as any other semi-automatic rifle. Assault rifles are designed to be capable of automatic fire, but assault-style rifles are not. And I even debunked this claim in my previous video by putting civilian-style firearms and assault-style firearms head-to-head in a fire rate test. And they're identical. So as you can see, any claim that assault-style firearms can fire faster than civilian-style firearms is just nonsense. In paragraph 349 of Justice Kane's ruling, Professor Brown even acknowledges this. And it's further backed up by Mr. Smith in paragraph 537, where he said, Mr. Smith noted that the definition proposed by Mr. Bader would mean that the variants of 7 of the 9 families would only include fully automatic firearms, since the semi-automatic variants explicitly listed in the regulation do not have the same frame or receiver as the original fully automatic version. He added that fully automatic firearms are already prohibited in Canada, and I'll add, they've been prohibited for close to 5 decades now. And this paragraph tells us 2 things. First off, assault-style firearms are not assault rifles because they're incapable of automatic fire. And secondly, assault-style firearms do not actually share the same design as assault rifles because their designs have been specifically and intentionally redesigned to deliberately reduce their fire rate by making them incapable of automatic fire. And this obviously differs rather significantly from the claim in the OIC, which says that these firearms are designed to have capabilities for the military with the purpose of killing humans in large numbers within a short period of time, given the characteristics they possess. So as you can see, both the applicants and government expert testimony agree that assault-style firearms do not have the capabilities that the OIC boldly asserts that they have. Assault-style firearms do not have a design, lethality, fire rate, or capacities which would enhance their capabilities beyond their non-assault style counterparts. In fact, as far as Mr. Smith and the Canadian Firearms Program are concerned, the appearance and ergonomics are the most important factors, not the internal mechanical operation as the government would claim. Testimony from both sides of the trial confirms this. So why then did Justice Kane get this so wrong? How is she unable to determine this information for herself despite the fact that she wrote all of this down in her own ruling? Remember, this ruling is in her own words. This is a first-person account of what she saw at trial and how she decided to rule because of that. Well, this all happened because she didn't want to ask the question. She deliberately avoided the issue and intentionally refused to investigate the definition as she was actually supposed to be doing. Now keep in mind, she's not required to do this of her own accord. Again, she's not there to do the work of the applicants for them. But as I've said already, all of these things were frequently asked by the applicants. She is supposed to be addressing these criticisms. And I suspect that she avoided doing it because she knew what answers such an analysis would bring. So instead, she made up a weak excuse in order to avoid having to analyze it at all. Now, I know that sounds a little conspiratorial, but the case that I presented in this video so far is logically consistent, and it's not based on anything other than the information that Justice Kane had direct access to. I just merely followed the breadcrumbs to see where they would lead, whereas she appears to have buried her head in the sand by refusing to even investigate at all. And if that's not evidence of bias or prejudice, then I don't know what is.